The judgment in the appeal, MS Uganda.
The judgment in this case was written by Lord Hughes, but he cannot be here today, and so I shall try to explain the unanimous decision of the court. It is an immigration case. Immigration decisions are made in the first instance by officials on behalf of the Home Secretary. The claimant has a right of appeal to a judge in the first-tier tribunal against most of the important decisions. This case is concerned with the scheme for such appeals as it existed under the Nationality, Immigration and Asylum Act 2002. The scheme then in force has now been changed by the Immigration Act 2014, but the 2002 Act continues to govern this case, and there may be some others like it in the pipeline. One kind of immigration decision which needs a right of appeal is the refusal of a claim to be recognised as a refugee. That is, a person with a well-founded fear of persecution in his home country because of his race, religion, political opinions, or membership of a particular social group. Under the 2002 Act, there was no general right of appeal against the refusal of refugee status. But this did not matter, because there was a right of appeal against the Home Secretary's directions that the person must leave the country, or the refusal of leave to stay here, which usually accompanied or followed the refusal of refugee status. And the claimant could challenge the refusal of refugee status in that appeal. Sometimes, however, the Home Secretary might decide that the claimant was not a refugee, but nevertheless grant him the right to remain in the United Kingdom for a limited period. The normal rights of appeal would not then arise. So the Act gave such people a special, separate right of appeal. This arose where the refugee claim had been rejected by the Secretary of State, but the person, quote, has been granted leave to enter or remain in the United Kingdom for a period or periods exceeding 1 year, end of quotation. The question for this court was what those words meant. Could the grant of leave to enter or remain for a year or more have been at any time in the past? Or had it to start at the same time as or after the decision on refugee status? Or at least had the 12-month period to run from the time of refusal of that status? This appellant had initially been given leave to be in the United Kingdom as a student. He had had a total of more than 12 months' leave as a student. Towards the end of his leave, he applied to be treated as a refugee, but his claim was refused. When that happened, he still had about 11 weeks of his student leave to remain left. He argued that he had the right to appeal against the refusal of refugee status because he had had a total of more than 12 months' leave to be here. This court holds that the purpose of this special extra right of appeal was to provide a safety net appeal for people who would not have the normal right of appeal for at least a year. This appellant did not need the safety net because his limited leave to remain here would expire within 11 weeks. He would then either be required to leave the country, in which case the normal right of appeal would arise, or his leave to remain would be extended, and if it was extended for a year or more, he would have the extra right of appeal. So what those words mean is that the 12 months period of leave which has been granted must run either from the date when refugee status is refused or from some later date when the leave is granted. It would make no sense if a grant of leave to be here, for example as a student, which expired many years ago, could found this extra right of appeal. That historical fact would have no bearing on whether the claimant needed the extra protection given by this right. The appeal is therefore dismissed, although not for exactly the same reasons as those given by the Court of Appeal.